Thank you, Daniel. So, Cynthia, why don't you introduce Elizabeth formally, and then turn it over to me for just a second.
Okay. So I want to welcome everybody. Good morning or good afternoon, kind of depending on where you are. Thanks for attending our 3rd out of 4 session on different financial, tax, and estate planning matters. We're excited to have Elizabeth Bodden with us today to discuss estate planning during COVID-19 and beyond. I think it'll be really exciting, and she'll offer some great information that you might not know about. As Matt mentioned, my name is Cynthia Zami, and I'm the Director of Plan Giving for the West Coast for JNF. I'm joined by my colleagues, Robin Dermer, Bill Adolph, Judy Feig, and of course, Chief Plan Giving Officer, Matt Bernstein. Today, we're fortunate to have Elizabeth joining us. She'll be discussing estate planning and legacy planning in our current and very, unexpected situation, as well as what we can look forward to in our new normal. Elizabeth is an attorney and a partner at Withers Bergman and works out of their LA office. Withers Bergman is an international comprehensive law firm with offices all over the globe. Elizabeth loves to help clients make intentional decisions regarding family and legacy planning. And I'm going to let Matt say a few words about her because she has done a lot of work with us, and we really appreciate that. Matt?
So I thought it was important for our JNF people to know. I met Elizabeth back in 2012, I think is when we started, as a result of an extraordinary bequest that was being left to Jewish National Fund that needed legal expertise, which she provided to us. She's an extraordinary attorney. But not only were there legal expertise, is that there was a lot of finessing on how to speak with the other trustees. And I just want to put it out in the record. Elizabeth and I think, spoke 3 times a day for 3 years in a row. And then the bequest was realized. And not only is she a terrific attorney, she knows what she's talking about. Whenever we have a problem or we have a question we can't answer, we go to her, she gives us a great answer. But I say this unabashedly, unashamedly, without her assistance in this bequest, I don't think we ever would have received it. So not only was it legal and the work she did for us on a legal basis, but the manner in which she was able to speak, and I don't want to use the word handle, but communicate with the other side, we were able to realize our bequest a full 18 months before we might have. And so I always said to her personally, and now publicly, Elizabeth, thank you. You did a terrific job for us, and we're lucky to continue to work with you. So the rest is yours.
Thank you so much, Matt. That is so kind of you to say. The gift that Matt's talking about was a fascinating one to work on, and one that I really enjoyed being a part of, and I was really glad to be able to help facilitate that for JNF. So today we are here to talk about estate planning with a particular emphasis on these uncertain times and how COVID-19 is affecting things and kind of what you need to know. So this will be a quick overview that I hope will be helpful in just giving you a framework of kind of what every person should be doing in connection with estate planning. And I chose the image of the tree on the slide, not only because it is so connected to the work of JNF, but also because a good estate plan is like a well-watered tree that provides shade and opportunity, and the ability to leave a long-term legacy. So I thought a good way for us to start today. So the first question that I get asked a lot is, why should you do estate planning? Many people will say, gee, I'm happy with the defaults in the law. So I'm married, I believe that if I get sick or pass away, my spouse will be able to make decisions, and that's fine. But what people often don't realize is that planning is much more efficient. Even if you're comfortable with some of the default options, often without proper planning, getting to them requires going to court. And the period that we're in right now with COVID-19 is demonstrating that for people who are relying on court processes, there are problems. And so, you know, if I had to go to court today to lodge a will or get a conservator appointed, I would not be able to do that. And so having a plan that you've done intentionally can ensure that regardless of what's going on in the world, there's the most efficient process in place and the one that puts you and your family in the best possible position. Another reason to plan is that it gives you the opportunity to ensure that your wishes are carried out by the people you trust. Most of us assume that those close to us know what we care about and know what our wishes are. But more often than not, I find that's not always the case. And so doing estate planning gives you that forced opportunity to capture some of those things that are important for your loved ones. And then finally, you know, doing estate planning gives you the opportunity to leave a legacy. Legacy, of course, is something that is left regardless of planning. But without planning, you know, is often one of headache and lack of clarity. And with planning can be something where the family says, gee, we knew exactly what she wanted and how she wanted it done. We knew what was important to her. And the things that were important to her, you know, were carried out. One of the most common things I hear from clients after a loved one has passed away or gone through a serious illness is gratitude for those that did advance planning. And so that, I think, is a great reason to plan. And this quote on the right-hand side really sums it up well. Do something today that your future self will thank you for. So we know why you should plan. What exactly is estate planning? We hear people talk about it, but do we know what it is? I think of it simply as a process of making intentional choices. And there are three broad categories of intentional choices to consider. The first is incapacity and legacy, which is often one of the most overlooked aspects of estate planning. So most people focus on what's going to be in my will, what happens when I pass away. But often what we care more about is what happens while we're here. Who's going to make medical decisions for me if I'm not able to make my own? What medical wishes do I have? Who's going to handle my financial affairs if I'm temporarily incapacitated? And then finally, at the end of my life, you know, what do I want said or done? The second aspect of estate planning and making these intentional choices is thinking about care of dependents. Nobody wants to think about that, but it's one of the most important decisions to make, though thankfully one that we rarely use, at least in the context of minor children. But we want to think intentionally about, you know, if we were to pass away and have a minor child left without our, you know, care and custody, who would we trust and want to care for our children and raise them with our values and love until they reach adulthood? And maybe even more importantly, if we have adults that we care for, whether that's our parents or disabled siblings or children, making sure that we've intentionally thought about and planned for a time when we can't care for them. And then finally, thinking about the disposition of property. This is, of course, what everybody focuses on, even though the first two perhaps have more impact on us, certainly while we're living and on the people we care about. But, you know, certainly property is what is talked about most in estate planning. And so it's important then to understand, how does property pass at death? Most people tend to assume that property passes at death based on what is in your will. Or if you don't have a will, whatever the default state laws provide where you live. But really, there are three primary ways property passes at death, and a will is only one of them. The first is beneficiary designation. So I'm assuming many of you are familiar with retirement accounts, bank or brokerage accounts where you can designate a pay-on-death beneficiary. In some states, we even have the ability to designate a beneficiary on the deed to our house. We call that a transfer on death deed. It's pretty new. But where I practice in California, we have had that for about 2 years now. And then life insurance, where you designate a beneficiary. And so any assets that have a designated beneficiary will pass to that beneficiary at death, regardless of what your will says, and regardless of what other estate planning you are doing. And so it's important to understand that, because many people often think, oh, if I do a will, that's gonna kind of supersede everything else. And that is not the case. It's also really important to understand this, to make sure that you have beneficiary designations in place that reflect your wishes. It's not uncommon for someone, when they take a job, to designate a beneficiary at that time, and maybe 30 years later not have updated that beneficiary designation, even though their circumstances have changed. Maybe they've married, had children, decided that they'd love to leave a legacy for JNF, and simply not having updated the beneficiary designation at that point. The second way that property can pass at death is by agreement. And there's a couple of different types of agreements that people make to have property transferred. And probably the most familiar is the joint tenancy. So this is when you jointly have a bank account with somebody else. And by default, if one of the two of you pass away, the survivor owns the bank account. Real estate is often held as joint tenancy with the words right of survivorship after them. And that has the same effect, for the property to automatically pass to the survivor of the two owners. In some states, certainly in California where I practice, we have community property. And there's an asterisk there because community property is a little bit tricky. But there are circumstances where your spouse's community property already belongs half to them when you pass away. And sometimes automatically your interest passes to them, but not always. And then there are trusts, and revocable living trusts, as well as irrevocable gift trusts, are two types of agreements that cause property to pass at death. And just like with beneficiary designations, these agreements override what's in your will. So again, if you have a joint bank account with someone, that account is going to pass to the joint owner at your death, rather than be distributed according to your will. And that's important to understand, because it's very common sometimes for a parent to put a child who lives close to them as a joint tenant on the bank account, not realizing that the account will then automatically pass to that child, to the exclusion of the other children when the parent passes away, even if their will says something different. And then the third way property passes at death is by a probate proceeding. And essentially, anything you own that doesn't have a beneficiary designation or isn't subject to an agreement will pass by a probate proceeding. So one of the biggest questions I get asked as an estate planning lawyer is, what is probate? People have heard about it, but don't necessarily know what it is. And, you know, it's essentially the state's legal process for authenticating your will, so making sure it was validly executed. And in this time of COVID-19, we're having a lot of tricky issues relating to that, because many states require a will to be witnessed by two disinterested people who are in the room with you when you sign. And yet, when I talk to my clients, they say, I have no way of having two disinterested witnesses in the room with me when I sign, particularly if they're in a state with shelter-at-home orders in place. And so we have seen quite a number of states pass emergency legislation for how wills can be executed during this time, but another significant number of states, including California, haven't done that. So just a note that, you know, the sooner you can do planning, the better, so that you're set up well in a time like this. So the probate process involves authenticating a will, and I say if applicable, because you can have a probate without a will, where we just follow the default laws in your state about who inherits from you. Once the will is authenticated, if there is one, the probate process then requires the identification and notification both of your beneficiaries as well as your heirs. And the distinction there is that your heirs are the people who would inherit from you if you didn't have a will. So for many people, they're the same, but for some people, they may be leaving their assets in their will to people who are not the default heirs who would inherit from them otherwise. In a probate process, the court appoints a personal representative, often called an executor, but sometimes called an administrator or other similar terms. And their job is to locate and value the decedent's assets, to make sure any debts get paid, to make sure tax returns are filed, and then ultimately to distribute the assets to the beneficiaries of the deceased person. So if probate is simply the state's legal process for these things to be done, and as you might guess, these things for the most part are going to happen regardless of whether a court is involved when someone dies. Is there any problem with probate? And that's the next most common question I get asked, which is probate bad? And the answer is not always, but there can be drawbacks. And so probate is court supervised, which means that for any key decision making, you're having to go to a judge. And in some states, that process can be pretty straightforward. And in other states, such as where I practice in California, that process can be pretty complicated and might take, 2 months for me to get in front of a judge to get an answer to a question that's required. Another aspect of probate is that it's very public. So as part of the probate process, typically not only is your will filed, but information about your assets, your beneficiaries, your creditors, and other information that most people consider private does become a matter of public record. Now, for most of us, this isn't a big issue, but of course, you see it when celebrities or other famous people pass away, and the media either is or is not able to get that information, and it hinges on whether there's a probate process. Probate tends to be somewhat inflexible, so the state rules in the state where you live, are what they are, and whether or not they fit your situation or your family, you have to follow them. And then probate costs can be very high. So the examples I've given here are from, again, California, where I practice. But the cost of a probate, typically involves court filing fees of at least $1,000, executor and attorney fees that run anywhere between 2 and 8% of the overall value of assets, and potentially more. And then appraisal fees. In some states, however, the costs are much less. So I recently had to do a probate in Arkansas, and the costs were substantially less than they are in California. And so in your state, probate costs may not be as onerous as they are elsewhere. Probate also can be time consuming. So again, with my experience being in California, when I file a petition for probate, it typically takes 6 weeks for me to get a hearing before a judge. And then once I have that hearing, it typically takes another 6 weeks for me to get the court's orders appointing the executor. And from that point, there's a minimum 4-month waiting period. And even if we could get all of the work that was listed on the prior slide done during that 4-month waiting period, when I file a petition asking the court to distribute the property to the beneficiaries, I'm going to wait typically another 2 to 3 months for the court to grant me a hearing where it will review my request and approve it. And then I wait another 4 to 6 weeks for the court's final order. And so you can see with all those waiting times that even in the fastest of situations, we're probably looking at 9 months. But in the average case, it's quite a bit more. And this is another situation where, whether it's in California where we have long delays, or in other states where the delays aren't quite as long, when the courts are closed, nothing can happen. And so, some states have started to adapt and have hearings held online through Zoom, just like we're holding this session today, but other states like California haven't been able to do that. And so we are waiting. And I have a number of clients right now that say, gee, we wish we had planned to avoid probate. Certainly in California, I am advising almost all of my clients to plan to avoid probate because of some of these drawbacks. And, for every state, the answer is different. But if you want to plan to avoid the probate process, the primary strategy that we use is a revocable living trust. And so think back to our slide on the 3 ways property passes: by beneficiary designation, agreement, or probate. And it's that middle option, by agreement, that a revocable living trust falls into. This involves creating a trust, transferring all of your property to that trust under an agreement during your life. And when you pass away, because that agreement governs where your assets are transferred, there's nothing left for a court to consider as part of a probate proceeding. So understanding what a revocable living trust is can be one of the harder tasks or goals as part of the estate planning process, I explain it to my clients as a bucket. So I say, look, a revocable living trust is a container or a bucket, and you're going to put this bucket together while you're living and have capacity, and you're going to put everything you own into it. So you're going to put your house into that bucket. You're going to put your bank account into that bucket. You're going to put the artwork in your home into that bucket. And you can carry that bucket around. You control it. You can take things out of it. You can put things back into it. So, you know, while you're living and have capacity, you're managing your property just like you do now. You can amend or revoke the trust agreement at any time. You can change what it says. But upon your death or incapacity, your designated successor trustee can easily take over as the manager of that bucket. So you think about it as just handing the bucket from you to the next person. And the trust agreement instructs your successor trustee how you want your property managed and distributed. So that trustee really becomes what we think of as an executor. And they're going to do all of the same jobs that someone is doing as part of a probate, but there just won't be any court process involved. And because we don't have to involve the courts, we typically find that the costs of administering a revocable living trust are substantially less than the costs of a probate, and that it is much more efficient. Certainly in a time like we are in today, my clients who are using trusts have had much more favorable experiences having to deal with the affairs of loved ones without going to court. So we know here what a revocable living trust is, but what isn't it? So clients often ask me, you know, or they'll tell me, I have a revocable living trust, so I'm good, right? All of my tax planning has been done. And when they ask me or tell me their revocable living trust avoids taxes, I tell them not necessarily. This trust can incorporate tax planning, but it isn't in and of itself a tax savings mechanism. So assets in the trust are still owned by you, you know, because you can use them as you wish, take them in or out of the bucket. For tax purposes, the government views them as yours. You can incorporate some tax planning into the trust by making sure that you maximize the estate tax marital deduction that allows you to leave things to your spouse when you pass away. You can incorporate provision that preserves to the maximum extent the amount that you can leave tax-free for your children or grandchildren. And you can also allocate tax unfavorable assets to fund gifts to organizations like JNF. But those are all provisions you'd have to write into the trust, and the trust by itself doesn't avoid tax. The key trust benefits are probate avoidance, privacy, efficiency, and intentionality. And just by way of review, I've included on the right-hand side of the screen a little information about estate tax. So currently, each of you have a $10 million exemption from estate tax. This allows you to give away assets either during your life or at your death, or in a combination of the two, up to that amount without any estate tax applying. The $10 million is adjusted for inflation, and so in 2020, we're already up to 11.58 million. But that number is scheduled to be reduced by half in 2026. And of course, Congress could change it in any number of ways prior to that time. Any assets that you have in excess of your exemption are taxed at a 40% rate under current law when you leave them to your beneficiaries. And so simply using a revocable living trust doesn't avoid that tax, but again, can incorporate some planning into it. So what are some ways to minimize tax and leave a legacy? I've broken them down here into lifetime opportunities versus opportunities at your death. And, you know, we are all thinking in these uncertain times about, you know, how we can be of help to our families, to our communities, to the world as a whole. During our life, we can make gifts to family and friends. There is something called the annual exclusion that allows us to give $15,000 per year to any number of people that we would like without using any part of that $10 million exemption I mentioned on the prior slide. There are also very generous provisions in the code that allow you to directly pay for someone's education or medical payments without being treated as making a gift to them. Just be aware that those payments have to be made directly to the school or to the medical provider. And then finally, there are some wonderful opportunities to leverage the $10 million exemption that you have to maximize what you can leave for family and friends. And then, of course, there's charitable giving. The CARES Act that was passed in March has some wonderful incentives for those of us who are able to give back this year in an even more generous way than usual. For non-itemizers, people who don't itemize their income tax deductions, there's the ability to deduct $300 of charitable gifts. And for those that itemize, there's a removal of the cap that would usually apply to how much of your cash gifts you can deduct. Of course, any charitable gifts that you give do come with an income tax deduction if you're an itemizer. And we even have some wonderful options to both support organizations like JNF and give to your family and friends. And I know that Matt and Cynthia and the team would be thrilled to talk with you about those. At death, we have some great planning tools. The first I've already mentioned, which is using the marital deduction to make sure that no estate tax has to be paid if you pass away prior to your spouse, to ensure that the family can continue to live as it did prior to your passing. And then there's also some wonderful charitable giving options. One of the options that I'm talking with people a lot about right now is retirement plan beneficiary designations. So prior to the onset of COVID, at the end of last year, Congress passed something called the Secure Act, and it removed some of the favorable options that you used to have to leave your retirement accounts to your kids and have them roll over those retirement accounts for their entire lifetimes. And we have some wonderful ways using charitable giving to accomplish something similar, even though the Secure Act eliminated those direct options. So you can use your retirement plan at death to fund a charitable gift annuity for your loved one, to create a charitable remainder trust for your loved one, or simply take your retirement account and designate JNF as the beneficiary, completely eliminating any income tax on that retirement account and leaving your other assets, which are never going to be subject to income tax, on to your loved ones. So some really wonderful ways both to minimize tax and leave a legacy. And these gifts at death can be accomplished in any one of the 3 ways that property passes at death. So again, using beneficiary designations, using a revocable living trust, or simply including these gifts in your will. So I thought we would wrap up by including some specific action steps that may be helpful, just kind of in where would I advise somebody to go from here. The first is to spend some time thinking about what's important to you. And so on the screen are the major categories of things that I recommend clients think about before they meet with me. So who would they want to be their financial decision maker if they can't handle their own finances for either a short or long period of time? Who would they want to be their medical decision maker? And do they have any particularly important wishes regarding their medical care? This can range from everything to specific medical conditions they would want to make sure someone knows about, to particular wishes for care. So I have one client who insisted in his medical directive to say, look, if I'm ever, incapacitated and can't speak for myself, I want football playing on the TV because that will bring me comfort. And I have other clients who've said, I do not want the TV on because that would drive me crazy. And so you can deal with all aspects of care in that document if you wish. Thinking about who you'd like to leave financial assets to. Those are your beneficiaries. So who are the people, who are the organizations that you want to share your wealth with, and what's the best way to do that? And then finally, what or who and how would you like to provide to care for dependents that you may have? And all of these together are what will help ensure that you leave a legacy that is meaningful to you and to those that you care about. So once you've spent some time thinking about these things, the second action step would be to implement this by visiting your estate planning attorney. People often ask me, what do I need to bring when I see the attorney? And the key things that I suggest are a list of your assets and their approximate values, because that's going to help the lawyer tailor a discussion to your situation, and also be able to discuss with you those 3 different ways property passes and make sure that you have a coordinated plan in place. Second, any prior estate planning documents you've done, even if you know that they're out of date and you don't like them, the prior attorney is always going to want, or the attorney is always going to want to see those prior documents. And then finally, names, birth dates, contact information, all written down. Once you meet with a lawyer and develop a plan, of course, the key final action step of implementation is to review and sign the documents that are prepared. That's the least fun part of estate planning. So clients often, feel like they've gotten so much done. They finally checked off their list going in to meet with a lawyer. But they sometimes fail to kind of take that final step of getting the documents signed. So you don't want to overlook that. Just so you know what to expect, at the end of the estate planning process, I would expect every person to have 4 sets of, or 4 documents. The first is a power of attorney that names your financial decision maker in the event of incapacity. The second is an advanced healthcare directive or power of attorney for healthcare, depending on what your state calls it, where you designate a medical decision maker. And then the third is a will. And everybody should have a will, even if you are planning to avoid probate through one of our non-probate transfer options. So beneficiary designations or a revocable living trust. And then finally, you're going to have some non-probate transfer documents. So you may have a trust. Even if you don't, you're going to have some beneficiary designations in all likelihood. So you've prepared, you've gotten your estate planning signed. The final action step is keeping it up to date. So people will often ask me, you know, how often do I need to update my plan? And I tell them, you know, every 3 to 5 years, you'll want to be looking at your documents and just saying, do these documents still reflect my wishes? As well, anytime you have a major change in family, relationships, finances, move to a new state, because each state's laws are slightly different, or if there's a major change in the law. So hopefully this will kind of give you a good set of factors to use to think about when you might want to make changes. And then finally, as some additional resources, JNF has a great website at jnflegacy.org where they have information for you regarding estate planning. And their team are more than happy to talk to you about any of these topics and how they can be of help. So I think that's it on my end.
Thank you very much, Elizabeth. It was really wonderful. We have some questions that have come in, and I'll start with the first one, and that is, does my trustee have to be the same person I designate as my healthcare agent?
That's a great question. And the answer is no. So it is pretty common for people to say, there's one person that I really trust to handle financial decisions. That would be your power of attorney. And there's somebody else who may not be the best candidate for financial decisions, but who I know would really make sure my care was taken care of the way that I want. And so it's perfectly fine, and in fact, quite normal to name different people.
Okay. And the next question that we have is, if I want to leave my savings account to Jewish National Fund, can I make Jewish National Fund the beneficiary of the account instead of changing my trust? And will that go through probate?
Great question. So if you make Jewish National Fund the beneficiary of your account, that does fall into that first category of ways to transfer property at death. The account will then automatically pass to JNF at the time of your passing, and it will do so regardless of what your will says and without having to go through probate. The key there is just making sure you always have that updated and correct beneficiary designation in place and on file with your financial institution.
Excellent. Another question is, there is a real estate tax if somebody transfers a title of a house to a trust or to joint tenancy. Some people sell it for $1 to avoid the tax. Would it cause the capital gains tax if the house is subsequently sold to somebody else at a real price at arm's length? And this was asked by Eugene.
So there's a couple of things wrapped up in that question. The first is, you know, are there transfer taxes when you take a property and transfer it from your own name into a revocable living trust? In the vast majority of states, the answer is no. But that is a state-specific question. But in most states, there is a recognized exception that if you are transferring the property to a trust that you're in charge of and that's for your benefit, there's no initial real estate transfer tax. If you did actually sell the property to your trust, and I would really defer to your local estate planning attorney for this. That should be fine if the state law would effectively allow you to avoid real estate transfer tax on that. Because for tax purposes, your revocable living trust is no different from yourself. And so for tax purposes, that's like you selling your house to yourself, and there's no capital gain tax to pay. Regardless of how you get your property into your revocable living trust, that trust has your income tax basis in the property, so whatever you paid for it. And if you sell it later, you'll pay capital gain tax on the difference between your basis and the sale price.
Okay, thank you. And Eugene, if you have any follow-ups, you can just post the question. In the meantime, the next question is there anything that could be done to minimize taxes if the estate is over the $10 million exemption amount?
Yes, so a lot of the work that I do as an estate planning attorney is with clients who have estates that are over that $10 million threshold. And there are some really wonderful opportunities to minimize tax. Some of them are particularly appropriate for people who are also philanthropically inclined. So we have ways to combine your charitable giving with your estate tax exemption to kind of hit a home run for you and for the organizations you care about. And then there's also some other planning techniques that, for better or worse, are actually really appropriate to the environment we're in today. So we saw in March the stock market lose quite a lot of value. And I think everyone believes that that value will be recovered because it was lost, not because there was some underlying weakness in the companies, but because of COVID. And so if you believe your stocks will recover value at some point, we have some great planning tools that would allow you to effectively share all of that appreciation with your beneficiaries without paying estate tax. So there are a whole bunch of techniques, and that's where you would definitely want to talk with your estate planning lawyer.
Okay. If we have a few more questions, but we want to make sure everyone has an opportunity before we close the session. So if anybody has any questions, if you want to just raise your hand, we can call on you following this next question. And the next question is, given the constant changing of laws, how can someone plan today and protect the tax advantages of the big exemption we have now, even in the future?
Great question. I always tell clients first and foremost to plan based on what the law is today, because that's all you know for sure. And then know that you might have to revise course if the law changes in an unexpected way in the future. But based on the fact that we know that unless Congress does something different, the exemptions will be cut in half in 2026, what a lot of clients are looking at is ways to lock in their exemption now. And the most effective ways to do that are workable for people who are willing and able to start giving away control of some of their property now. So it's hard to answer in any particular way, but there definitely are strategies and techniques for doing that.
Okay, thank you. And if anybody who's on the call wants to, can we unmute them so they can ask any additional questions before we close the session?
You can just raise your hand if you have a question.
I don't see any hand raises, Robin, but I think we have one or two more in the chat.
Okay. Let's see, the next one in the chat is, do you get a stepped up cost basis in a revocable living trust?
Great answer. I mean, great question. So,
I think
you know, I mentioned that when you put property into your revocable living trust, your income tax basis just transfers to the trust. And at the time of your death, anything in that revocable living trust, because it is owned by you, does get an income tax basis adjustment that is referred to as the stepped-up basis. And whatever the assets are worth on the date of your death becomes their new income tax basis. So those who inherit them from you can sell them at that time with minimal gain or loss.
Okay. It was asked, and we will be sending out a thank you for your participation in the call, as well as the slides that you have seen. If there's nothing further, I think we can end the call.
So I just wanted to say a few words, if I might. It's kind of funny, Elizabeth and I spoke about this presentation, obviously, before it happened, and she was telling me how incredibly busy she's been. I think that all of us know that, you know, estate planning is just last on the list. It just is. You have a to-do list and nobody wants to think about this. Once you have it in place, you feel good and you're comfortable and you can sort of breathe a sigh of relief. But I think with us all sitting, you know, at home for the last couple of months, this is one of those things that you might want to consider updating or creating if you don't have one. Because it's the perfect opportunity to be talking about this with your family, your loved ones, etc. So I know that, you know, Jewish National Fund's mission, and I think everybody can appreciate that here, is the preservation and strength of the land of Israel. And we really appreciate your support and your dedication. And Elizabeth has given us a lot of great ideas on how to continue that support and dedication even after you're gone. Because the reality is we're preserving Israel for ourselves, but also for the future generations, for our children, even for our grandchildren, even our great-grandchildren. And many of us, you know, everybody on this call obviously is not living in Israel. But the people living in Israel, the work that Jewish National Fund does is protecting our Jewish homeland. Not just their Jewish homeland, but our Jewish homeland, the people that live outside the state. And without your help, Israel really can't do it. They need us to be there for them. And so I think Elizabeth gave us, you know, so many great ideas. And there's definite assets that if you're thinking about leaving them to your loved ones or your family members versus leaving them to Jewish National Fund, which assets are the best ones to leave to Jewish National Fund and which assets are the best ones to leave to family members or loved ones. And most of it has to do with tax issues, income tax issues, estate tax issues. And that's something that myself and our team, Rob and Bill, Judy, Matt, would love to have a conversation with you about. I know this comes up for me a lot. People say to me, you know, I want to do this, but I'm not sure if I have the time right this very second to go to my estate attorney. And so Elizabeth gave us some really great ideas with beneficiary designations. If you have a, you know, savings account, definitely the retirement assets. If you're going to pick one asset to leave to a charity versus your children or loved ones, those retirement assets are probably the best assets to consider. And you can make that change with the beneficiary designation form online. I mean, I know ours is online for our retirement assets, Jewish National Fund. It's just a form that you fill out, quite frankly. And, you know, that's something that's revocable. So you can change it today, 5 years from now, 25 years from now. Jewish National Fund actually has a free wills guide. So if you're trying to think, how am I going to get all my information in a place that I can take to the estate attorney, you're going to get an email thanking you for attending this, and you can just flip us back an email saying, can you please forward me that guide? And we're happy to do that. It's just a booklet that's really makes your life a lot easier. So I want to say thank you so much, Elizabeth. Thank you so much. I know you're so busy. We so appreciate you doing this for us today. And I want to thank all the attendees for coming. I want to remind you that next Thursday at 11 a.m. Pacific time, 2 p.m. Eastern time, so Thursday, May 21st, we will be having our final session on real estate issues. So Chris Herthel from Moss Adams will be speaking about land valuation, real estate valuation, and landlord-tenant issues. I hope you will join us for that. It's our final session, and we're pretty excited about it. And then also, we will be having a virtual tour. You'll be getting an email at the beginning of June. And if you want to join us on a virtual tour of Israel, because we obviously can't go there right this very second, we'd love to have you join us. Thank you, and I hope you have a wonderful day. Matt, do you have anything?
I just have one question. First of all, Elizabeth, terrific. Thank you. I knew it would have been terrific. You mentioned you had a client in Arkansas. Is your practice limited to California and Arkansas, or do you work in other states as well?
So the only states where I'm licensed to practice law are California and Arkansas.
Okay.
But my firm is primarily an estate planning firm. And in the US, we're located in Connecticut, New York, and California, and have attorneys licensed in a number of different states. And so we can provide coverage that is broader than just my license.
Okay. Thank you. Terrific. We really appreciate it.
Great.
Wonderful.
Thank you. Have a
Thank you
great
so
day.
much.
Thank you all. If you have any
Thank you.
questions, give us a call. Thank you.